I'm Buck Benson. I am a partner of Barton Benson Jones law firm with over 20 years experience in land development and property owner association law. Today, I will be sharing what to expect regarding the new Texas legislation regarding the right of owners to appeal their ACC denial to the board. I'm going to share with you all some of the specific key points that your association needs to know and consider when deciding how to prepare for these ACC board hearings. Specifically, the section of the code we're going to be talking about is Texas Property Code 209.005.05, subparagraph D through subparagraph I. That's the most legal thing I'm going to say for the rest of the presentation. Great question. I think that the lawmakers were really wanting more transparency in associations. They wanted the ability for homeowners who felt like they've been denied by potentially a rogue ACC or ARC to appeal those decisions to the board. I think there was probably a sect of homeowners that were tired of the ACC or the ARC denying requests without giving them much notice as to why that decision occurred. A lot of this mirrors what happened in 2011, where the legislature made a real concentrated effort to create transparencies with HOAs in the state in terms of open meetings, public records. I think it's the same thing here. They want the boards and ACCs to be more transparent in their decisions. So I think that's really the genesis of this particular section. The other item in terms of the actual process and requirements, essentially what this requires now is that if a homeowner is denied their ACC request, then the association has to provide them notice of that denial, either certified mail, by email, saying why it was denied, what, if anything, they could do to basically get approval, and also that they have the right to appeal that decision of the ACC to the full board. What information needs to be included? I think we need to start with the premise of less is more. It needs to say basically why the application was denied, what, if anything, the homeowner can do to have it approved. It also needs to provide that the homeowner has the right to appeal that decision to the board. There needs to be sent in a either by certified mail, hand delivery, or by email. There needs to be some proof that the homeowner actually received it. I think it would be good to include a reference in there that if the homeowner is going to bring their attorney to the hearing, that they need to let the association know so the association can have their counsel present, so that if the homeowner shows up with their attorney, the association doesn't have their attorney, that we have to get in a situation where the board has to postpone it because they don't have their counsel present. Again, the legislature put this out there without a ton of guidance, and I fall back on kind of our experience in 2011 and 12 with the 209 hearings. The legislature created this process without giving folks a lot of guidance on the process. So I think overall it may feel like it's a little intimidating. So I would encourage boards and associations as they start this process that they seek out management company professionals, maybe attorneys with some experience in the 209 hearings as a kind of a baseline to guide them through these first hearings, the first few hearings. I think it's important to have somebody that's experienced and at least heard a few of these 209 hearings, at least, which are similar to this, be present and provide some guidance just on the overall process to the board. I think it's important when you start the process or the actual hearing that the statute is pretty clear in that the homeowner is given their opportunity to present kind of their case. The association can kind of present their case through its management company or through ACC member potentially. And then once the board has heard that information, I think it's important that if the board feels like there's going to be some good discussion going forward, they can basically close that hearing and say, listen, homeowner, we'd like to go ahead and convene or close the hearing, have the minutes reflect that specific point in time, and then say we're going to move into a settlement conference and talk about, have some free communication with the owner. The benefit of doing that is that once you've created that line of demarcation for a settlement conference, then potentially anything going forward after that should not be admissible if this situation ends up in litigation. So I think that's important to kind of create that line or that point in time. Also, I think it's important that the boards realize they're not obligated to make a decision at that meeting. They can convene into executive session after the hearing and discuss it, think about it, and render a decision, a few days later. They don't have to do it that night. There's no pressure to do it that night. They can certainly think about it, evaluate all the facts, and come back and render a decision. Once a decision's been made, that needs to be communicated to the homeowner in some written documentation to confirm that they've received it. I think it can be by email as long as there's a read receipt, of course. And I think that record then needs to be, of course, saved in the association records. I think it's important, kind of going back, is that the association through its management company have kind of a template in terms of, what's going to happen at the hearing in terms of who starts, who ends, and then, when it's over. Also, the association really needs to through their management company, have a kind of a really firm template in terms of the minutes and what's said and done in the kind of the decision, because ultimately I think the associations are going to have to be very consistent with this process going forward. I think it's going to be very important for them to have a consistent set of documents and a consistent set of minutes as they move forward through these hearings. I think just in terms of the process, they need to remember that everything they're saying can be recorded by the board member. I think this is a situation by a homeowner that's attending these hearings. I think this is a situation where less is more. They need to be very consistent and clear in their justification for denial or approval of an appeal. I think as they do that, they need to be clear, because I think these are going to either that a denial or that approval more than not will create some precedent going forward. If the board has appealed or approved a certain type of shed as part of an appeal, then they're going to see that issue come up more often. I think also, as homeowners understand this process exists, you're probably going to see an uptick in folks that have been previously denied by the ARC, because now they have an opportunity to get that decision appealed to the board. Again, I think it's important for the boards and management companies to have a consistent process as they go forward through this to create some efficiency. Again, we're not sure if this is going to open the floodgates to homeowners appealing decisions. Hopefully it doesn't, but if it does, I think there's going to have to be a lot of consistency and so that there's some efficiency on the part of the management companies and boards as they try to implement this. I don't think a full board necessarily has to preside over all these hearings. I think you could have a quorum of the board, hear the decisions or hear the appeals, and then render a decision later. I think there may be a situation where you're going to have to stack multiple hearings on one night. Again, the legislature or the statute creates some timelines that the boards have to comply with in terms of giving notice to the homeowner, them requesting a hearing, them setting a hearing. I think all that stuff can be worked out with the owners to create some workable timeframes. I mean, it is. We saw that early on with 2009 hearings. Homeowners couldn't meet on a day, board couldn't meet on a day, so we extended that date to meet in writing. So, again, I think those are some things to keep in mind. Also, I think these hearings really are just meant between the board and the homeowner, and not necessarily don't have to be open to other members of the association. It can be really a one-on-one. That's all the time we have for today's episode of Ask the Expert. I want to say thank you to First Service Residential for organizing this great mini-series, and a special thanks to each of the board members who joined today. I would encourage you to reach out to your counsel if you have any questions on these issues. Again, thanks for joining us. Stay safe and have a great day.